Morning, everyone, to the Judiciary Committee hearing this Thursday morning, February 6th. We have one agenda today, 9:15 agenda. Just a few housekeeping points. We have a 2-minute limit on testimony, both on Zoom and in person, and I'll let you know when your time is up. If you can stay around for questions, members often do have questions, so that would be great. And if we have a catastrophic technical failure on the Zoom side, we'll try again on tomorrow, February 7th at 9:16 here in this room 016. But we will spend a few minutes trying to fix the technical problems if we have any. Fortunately, we haven't had any in a while, so I probably just jinxed it. All right, first up is SB 335, Senate Bill 335. This requires objections made by an officer of a political party to candidate nomination papers to be filed with and determined by the Office of Elections, as a number of other objections are already required to go to him first. First up is on SB 335 is Scott Nago, State Election Director.
Good morning, Chair. Thank you for the opportunity to testify. We'll stand on our written testimony for providing comments. We don't believe we would be the appropriate place to file a party challenge because depending on the outcome, we would have to file and advocate for that party in court. And I'll be happy to answer any questions.
Okay, thank you. That's everybody who signed up on SB 335. Would anyone else like to testify on SB 335 on Zoom or in person? Not seeing none. I do have a couple of questions. So, well, first of all, do you have any suggestions about how to avoid the problem? There's something to be said for having all the objections go through the same process. Is there a way to around your objection that everything would be funneled through your office initially, or are you?
It's hard because I see the pros and cons, but when it comes to party membership, it's different because what happens is if somebody files, prior to this current law, when somebody filed party membership, it would go to the chief election officer. The chief election officer would make a determination and then would have to file in circuit court to have that person disqualified. And then the issue was the attorney general would have to represent the chief election officer, which was representing, I believe in 1994, it was the Green Party, and advocating for the Green Party against the candidate. So it's almost like the attorney general was representing the Green Party, and that's why the law got changed.
But this doesn't come up with, because individual challenges come to you already, right? Why don't you have the same problem there? Because couldn't an individual challenge based on party membership?
No. So the way the law is written, the only entity that can challenge party membership would be an officer of the party.
Okay, so the other challenges are on different topics.
Different things like citizenship or residency or signature requirements.
Okay. Okay, thanks very much. We'll go ahead and move on to the next bill. Actually, I'm sorry. Before you go, I do have one more question. Sorry about that. What if we switched it around and just funneled all the challenges directly to circuit court as opposed to having you do any of them?
So the reason why I said I was torn between that is because when the challenges are filed, we need some sort of prompt finality because we still have to print the ballots, and it just depends on how long the court takes to resolve.
Oh, I see. So you appreciate the fact that some of your challenges you can get rid of quickly. Okay, thank you very much. Thanks for coming down. All right, next up we have SB 280. This amends the offense of negligent injury in the first degree to include injuries negligently inflicted by intoxicated drivers. First up on SB 280 is William Bento, Office of Public Defender. Good morning.
Good morning, Chair. My name is William Bentham from the Public Defender's Office. We do oppose the bill and we do make a couple of suggestions. We understand the concern here, but we do feel that causing a negligent injury, whereby that injury is pain, making that a Class C felony would be a little too harsh. So we suggest that if there is a strong need for this language to be part of the statutes, that it be amended, I'm sorry, 707, 706, negligent injury in the second degree be amended to reflect that same level of injury. But more importantly, there's really no definition of under the influence as opposed to our DUI or OVUII language in the statute. So we would strongly suggest that that be clarified as well as to what it means to be under the influence, because as I described in our testimony, one drink, a small fender bender that's really just an accident could result in somebody being charged and convicted for a Class C felony. Thank you.
Okay, thank you. Next up on SB 280 is Department of Transportation on Zoom, perhaps.
They're not present on Zoom, Chair.
Okay, in support, Daniel Hugo for Prosecuting Attorney of City and County. Daniel Hugo, Department of the Prosecuting Attorney, City and County, Honolulu. Good morning.
Good morning.
I'm sorry, SB 280.
Good morning, Chair Rhodes. Good morning, Senator Sam Buenaventura. This is an amendment to the negligent injury statute. Right now, if we see two distinct classes of drunk drivers, there are drunk drivers who are violating the law, but have not yet injured any person. And the purpose of the law in that case is deterrence, to encourage them to stop drinking and driving. People who have actually caused harm, we believe should be treated as a much more serious class. So this would propose in cases where they are under the influence of alcohol or drugs, they negligently cause bodily injury to another person, that would be treated as a Class C felony. Right now, they're charged in the same class as somebody who is stopped for a safety check violation, fails the sobriety test, but has otherwise not caused harm. We believe that that disparate treatment does not recognize the actual harm that's been caused in cases where somebody's been hurt because of drunk driving. I'm available for questions. Thank you.
Thank you. That's all everybody who signed up for SB 280. Does anyone else wish to testify on SB 280? Okay, seeing none. Seeing none. Senator Buenaventura, do you have any questions?
No,
Okay.
thank you.
So I guess for Mr. Hugo, I've been pretty anti-drunk driving over the years, but I mean, does this bill, I'm not sure it feels like it's sort of like overlapping with all the other things that could be charged. Negligent homicide in the second degree is a Class C felony, is the same as this statute in the bill, which seems disproportionate. And then one crime requires a negligent death, and the bill is proposing that basic bodily injury while driving under the influence is the same punishment.
Right. So in the case of negligent homicide, second degree, that's somebody who is negligent, but they weren't drinking and driving. So they've violated some sort of breach of legal duty. They might be speeding, for example, committing an infraction, but their carelessness caused someone's death. And so it's treated as a Class C felony. Here, the person who is under the influence of drugs or alcohol is committing a crime already at that time. And so that's why we see it as different from cases of just simple negligence that have a more severe result.
So in terms of, because bodily injury, well, there's like three different kinds of bodily injury, right? There's bodily injury, there's substantial or
And then serious bodily injury.
okay, so why did we pick just bodily injury?
Well, because in cases of substantial or serious bodily injury, we can already charge that as a felony,
Okay,
drunk or sober.
what class of felony?
It would be a Class C felony, I believe, because it would also be charged as negligent injury first degree.
And that's with when someone's drunk or when they're not, it doesn't matter.
Doesn't matter, just negligence.
Okay.
So it's negligence that had a more severe result, but not necessarily a criminal predicate.
So so in the current situation where someone's hurt, but there's alcohol involved, you're saying, what are you charging them as now?
So right now we would just charge the petty misdemeanor. Let's say that somebody hits a pedestrian. They don't break a bone, but they just cause a bunch of massive bruising. That person can only be charged with the OVUII at this point. We can't charge them with anything else because it doesn't rise to the level of substantial or serious bodily injury.
Okay, but so what you're saying then right now is what you're jumping a petty misdemeanor to a class C felony then?
Right. And the reason is because a person who's under the influence of alcohol and drugs, which is the phrase that we borrowed from the negligent homicide statute, but a person who is under the influence of alcohol or drugs is not just being negligent, they're committing a crime at that time.
Yeah, no, I get that part of it.
Yeah.
Well, if we raise it to just if we raised it to a misdemeanor as opposed to a class C felony, would that make it would raise the penalty for the same action, correct?
Yeah, the one difference is that misdemeanor investigations are treated somewhat differently from felony investigations. There's going to be a dedicated detective on a felony investigation.
Okay.
So, I mean, we would prefer, you know, if we have to split the difference and take a misdemeanor, we would prefer that over having nothing to charge. But in terms of the practical consequences of this, HPD is going to have a dedicated detective on these cases as opposed to it being treated like another misdemeanor, in which case it's just the patrol officers.
Okay.
So I have questions if you want to think about it.
Yeah, go ahead, Samir.
Okay, my understanding is the reason why we brought down a number of the DUI offense to petty misdemeanor was because the misdemeanor charge ended up backing up the system since everybody started demanding the right to jury trial.
Right.
Right. And my concern about this is without identifying the bodily injury and moving it up to misdemeanor, then we're back to the same offense. We're going to be back to the same problem of backing up the system. And the reality is everybody who had asked for a jury trial, the majority of which the prosecutor lost. So it seems to me it's better to get them into the system, even if it's a petty misdemeanor charge, you know, get them into the DUI court, get them, you know, instead of increasing, because any bodily injury, it could just be whiplash, it could just be a cut, and all of a sudden you bring it up to a felony or a misdemeanor, then we're back to clogging up the system again and basically not doing what the legislature, what we believe the community wants, which is basically get the drunk drivers off the street, get them into a system and not recidivate. So I would request that if you're going to bring it up, make it at least a serious bodily injury instead of just a cut or else a reckless or something if we're going to bring it up to a misdemeanor. But otherwise, we're going to be back to where we were before we brought it up, before we brought down the offense down to a petty misdemeanor.
Okay. So Senator Sam Buenaventura, first, if we raise it to a serious bodily injury, we can charge those cases already. The negligent.
That's back to where
Right.
the public defender is saying.
If it's recklessness, we can charge assault. The gap here is where we have negligence that causes bodily injury. Now, if it's raised to a misdemeanor, this issue about jury trials, they still have a jury trial on a misdemeanor. So I'll just note that. But the second thing is, in terms of the volume, there's a huge disparity in the volume between those cases where somebody is arrested just for violating the OVUII law. And then there's a smaller set where that involved a collision. And there's an even smaller set where that involves bodily injury. And we can prove. So the OVUII case is one of the difficulties with taking every DUI case to trial is that you might have the jury evaluating a case where, like I said, the person was stopped for a safety check. They failed the field sobriety test. They might have a bunch of explanations that the jury finds plausible. In cases where that person has hit someone and is under the influence of alcohol and drugs, the DUI conviction is not going to be an issue. Putting that case in the petty misdemeanor docket, the main defense strategy is just going to be to continue this case out as much as possible, because if that case goes to trial, somebody got hit, the person was drunk, we can prove inability to guard against casualty, mental impairment, the normal elements you have to prove. So I'm not worried about us taking these cases to jury trial. And it's a smaller set than the total set of people who are arrested for DUI, because again, the DUI law is there as a deterrent. We're trying to arrest people before they've hurt someone. But in the cases where they've hurt someone, unfortunately, we can prove that they had inability to guard against casualty.
Okay,
No other questions.
thanks very much. We'll go ahead and move on to the next bill, which is SB 292. This establishes safe harbor protections for survivors of sexual exploitation who seek medical or law enforcement assistance. First up on 292 is McKenna Woodward for the Office of Hawaiian Affairs. In support, next is Jerome Picaro for the Honolulu Police Department on Zoom, maybe.
They're not present on Zoom, Chair.
Also in support, Amy Zhao for Imua Alliance. In support, Michael Galoyu Senior in support, Dara Carlin in support. That's everybody who signed up on SB 292. Would anyone else like to testify on SB 292? Seeing none, we'll move on to the next bill. This one's relating to dogs. SB 301 establishes an additional penalty for a dog owner whose dog destroys property while on land zoned for agricultural use. First up is Nicole Galassi for the Hawaii Cattlemen's Council on Zoom.
They're not available on Zoom.
In support, next is Miri Yee. In support, Randy Cabral. In support, Woody Child. In support, Angelica Malone. In support, Sarah Moore. In support, Teresa Thompson. In support. That's everybody who signed up on SB 301. Does anyone else want to testify on SB 301? Okay, seeing none, we'll go ahead and move on to SB 356. It requires defendants convicted of causing the death or disability of a parent or legal guardian of a minor child by the operation of a vehicle while under the influence of an intoxicant to make restitution in the form of financial support to each child of the victim. First up on 356 is Department of Transportation, maybe on Zoom.
They're not present on Zoom, Chair.
Okay, in support. Haley Chang for the Office of Public Defender or Mr. Benton. Good morning again.
And good morning again, Chair Rhodes and members of the committee. William Benta from the Public Defender's Office on SB 356. We do oppose this bill, and we've outlined the reasons for that in our written testimony. I just want to highlight that it's our feeling and belief that with current statutory language dealing with restitution, the court could not institute or make the proper findings to make restitution in this manner. And that's why our feeling is that it's best left to the civil court. I just want to point out a couple of things that I noticed in the bill after our written testimony was filed, but there's a section that deals with a person who finishes their jail term and has a year after they finish to make their restitution payments. And I think the same is assumed for people who are on probation. I just want to point out for the committee that when a person maxes out or finishes their entire jail term, the court loses jurisdiction over that person at that point in time. Same with probation. The court loses jurisdiction once probation is served and expires. Our Supreme Court's already said that restitution or non-payment of restitution is not something that can prevent the expiration of probation or a jail term. So there would be no enforcement. And that's why the courts now issue a freestanding order of restitution at sentencing so that there's a civil judgment that follows the person with their case, even when the probation is done. And so again, it's left to the civil courts to take care of these types of situations. So in this case, with this bill, there's no way to verify what the restitution is going to be. Thus, the court could not order it, and thus there could not be an enforcement. That's why it's best left to the civil bar to take care of these matters. Thank you.
All right, thank you. Next is Daniel Hugo for Prosecuting Attorney of City and County. Morning again.
Good morning, Chair Rhodes, Senator Sam Buenaventura, Daniel Hugo for the Department of the Prosecuting Attorney, City and County of Honolulu. We support this bill. We do believe that there are mechanisms in place to allow it to reasonably be executed. a court has to look at 4 factors when it's assigning restitution. First, whether the restitution is reasonable. Second, whether it's verified. Third, whether there's a causal connection between the crime and the injury that was suffered. And then finally, whether the victim is actually requesting the restitution. And it's that first requirement that we think the court would look at in terms of setting a payment of support. They're obviously not going to be able to predict, do an actuarial prediction of the total support that would be available, but they can decide what would be a reasonable amount of support going forward. And yes, courts do issue freestanding orders of restitution, which can then later be enforced as civil judgment. So there is a mechanism for allowing restitution, which is a mandatory right that victims have now under the law, to be enforced going forward. That doesn't require the court to make it a part of their probation. I'm happy to answer any questions. Thank you.
Thank you. Next is McKenna Young for Mothers Against Drunk Driving Hawaii. Good morning. In support. Okay. Cecilia Williams in support, maybe on Zoom.
They're not present on Zoom, Chair.
Xavier Durnell, also possibly on Zoom.
Yes, they're present on Zoom.
Good morning.
Good morning, Chair and members of the community. I am in full support of this bill because I commute to UH Manoa and I drive my sister to Midpack every morning. So I've seen it all. I've seen all the drunk drivers. I've actually had people almost run into me because they're just being negligent on the road. And so I definitely would love this bill to be passed. There's something else that I would want to talk about. I'm not sure. I wasn't able to pick it up on the bill, but I would like it to also be given to minors too that are hit in the vehicle as well, that the parents can receive restitution for those minors. I'm not sure if that was specified in the bill, but I would also like that as well. I also think as far as the restitution goes, I was hearing some great points from the previous testimonies, and I think that as long as it's reasonable, that restitution should always be the thing. I think that the person hitting, being negligent, should have to face the full consequences and see how it affects not only just themselves, but the whole family of what they did. So thank you guys so much.
Thank you. Thanks for taking the time. Next we have
Thank you.
Bronson Teixeira in support. And that's everybody who signed up to testify in SB 356. Would anyone else like to testify in SB 356 on Zoom or here? Seeing none, Senator, any questions?
Yes.
Go ahead.
Public defender. So I've seen back when I was doing court-appointed cases that whenever I try to get my client released from probation, it always stops if they fail to completely make payments on their restitution. Is that still happening? I mean, they do everything that they're required to do. They can't get a job, but the restitution is so big. Is there, or is it because, my experience is Hilo, right?
I believe the discretion lies with the trial judge as far as terminating probation early. And there really isn't much criteria. I understand there's a working group now that's looking at the issues dealing with early termination. I think the studies tend to show that the shorter the probation period, the more successful the person usually is on probation. The longer term, there are issues with that. So they're looking at that right now, but currently it lies in the discretion of the court.
Okay.
However, if a person's probation is coming up for, the expiring date, 4 years, 5 years, and they're a month away, everything else is in order except restitution, that cannot be held against the person to violate their probation.
Okay, that's good to know. Second question I have is, like I said, I do personal injury cases too at one time. and they would get monetary damages. Is there a procedure where any kind of civil judgment that's collected in any way sets off the restitution amount? Or is that something that just gets brought up for the time to shorten the restitution?
Well, the language in this statute does address that, so there
Okay.
would be an offset. Currently, when we go to argue restitution, we will ask the court not to allow the person to have a double remedy, so to speak, that if they received compensation through insurance or through a civil case, that it offsets any restitution, because then they're receiving compensation twice. But I think it really depends on the case and
Okay.
and what that judgment, civil judgment is under the circumstances.
Okay, thank you very much.
Thank you. I do have one follow-up question. So the case that you mentioned that doesn't allow for restitution to go beyond the probation period, is that a fairly recent case? Has
No,
that been around a
it's
while?
been the practice for a while now, and that's why the court issues the freestanding order.
Okay.
Yes.
Okay, thank you. Let's go ahead and move on to SB 1284. This proposes a constitutional amendment to prohibit discrimination against a person because of ethnicity, age, disability, religion, national ancestry, sex, sexual orientation, gender identity, pregnancy, and pregnancy outcomes. First up on 1284 is Daintry Bartoldes, Executive Administrator for Hawaii State Council on Developmental Disabilities. Good morning.
Good morning, Chair, Senator Sanborn and Chair. We stand in very strong support of this measure. We'd like to thank the legislature for putting this proposed bill in. People with disabilities have always faced barriers, and by putting it into a constitution, codifying our support for people to ensure they're not just people with disabilities are not discriminated against. We really appreciate it. Thank you very much.
Thank you. Next is Judith Mills Wong, League of Women Voters of Hawaii. In support. Next we have Pride at Work on Zoom. Good morning.
Good morning, Senator Michael Gloria Jr., he, him pronouns, President of Pride at Work Hawaii. We stand in strong support of this legislation. It is, given our current political climate, it is time to enshrine all of these protections in our state constitution. And we do want to thank the crafters of this bill for having a clear and understandable question to be put before the voters. As a community that just dealt with a not so clear question, we really appreciate that, and we look forward to this bill passing and us having the opportunity to fight for these rights and put it before the voters to make sure that we actually enshrine these protections. Available for any questions, but thank you again for hearing the bill. Mahalo.
Thank you. Next is Abby Simmons for Stonewall Caucus of the Democratic Party of Hawaii, also on Zoom. Good morning.
Good morning. Aloha, Chair, Senator Bonaventura. My name is Abby Simmons. I'm the chair of the Stonewall Caucus of the Democratic Party of Hawaii, and I am in strong support of SB 1284. We stand on our written testimony, and I would like to add just a comment. We're seeing multiple illegal and bigoted executive orders by the divider-in-chief designed to erase the transgender community from accessing life-saving healthcare, participating in sports, obtaining federal identification that matches their gender, or just the ability to use a bathroom. These executive orders cause real-world harm that make up just to a population that make up just 0.8% of the entire population. So it falls on all of us to protect our community, and we respectfully ask you to support this bill. Mahalo nui loa for the opportunity to provide testimony this morning.
Thank you very much. Next up, we have Kathleen Odell, PhD, Chair of the Hawaii State LGBTQ+ Commission. Good morning.
Morning, Senators. My name is Dr. Kathleen Odell. My pronouns are she, her. I'm chair of the State LGBTQ+ Commission. I stand today on behalf of the Commission in strong support of Senate Bill 1284, a crucial piece of legislation that embodies the values of justice, equality, and respect that Hawaii has long championed. In the face of a nation increasingly divided by hatred, discrimination, and policies that seek to target vulnerable communities, this bill is not just timely, It's a statement of our unwavering commitment to human dignity and inclusion. As we witness the troubling rise of rhetoric and actions fueled by intolerance at the federal level, it becomes even more clear that we must take steps to protect those who are most at risk. Senate Bill 1284 seeks to mitigate the harmful impacts of national policies that perpetuate inequity and division. It serves as a powerful countermeasure to the growing culture of hatred and exclusion, ensuring that Hawaii remains a beacon of hope and a model for the nation in protecting the rights and well-being of all its residents. This bill aligns perfectly with Hawaii's core values, aloha, respect, and deep commitment to equity for all people. Language matters, and we must explicitly spell out our intentions. By passing this bill, Hawaii would not only provide vital protections for its own citizens, but also send a clear and powerful message to the rest of the nation. We will not stand idly by as others seek to divide us. We will lead with compassion, empathy, and the understanding that diversity is our strength. In this time of national discord, it's imperative that we take bold action to ensure the protection of all individuals, especially those who are most vulnerable to discrimination. Senate Bill 1284 is an essential step in that direction, and we urge you to support its passage without hesitation. Thank you for your time and consideration.
Thank you very much. Next we have Isis Osborne for Lambda Law Hawaii, a law student association. Good morning.
Morning, Chair, members of the committee. Thank you for the opportunity to provide testimony on this very important and timely bill. As others have said, given the federal political climate in the U.S., I think this is a very important constitutional amendment for us to be talking about. Us as law students, I think we really value the opportunity to bring legal discussions like this to the broader communities that we live in. I live on Kapahulu Avenue, and I'd like the opportunity to talk to my neighbors about what's going on and the potential to vote in favor of a constitutional amendment that actually protects folks like me, as well as folks with disabilities and all the other status and identity factors that are listed in this bill. So thank you so much, and I hope we can count on you all to vote in support of this. Thank you.
Thank you very much. Let's see. Do we have Celine Chang on Zoom?
They're not available on Zoom.
Okay, she's in support. And different, okay. And the Disability and Communications Access Board? Sure, Kirby Shaw, Executive Director. Good morning.
Good morning, Chair, Senator San Bonaventura. Apologies for the late testimony. My name is Elizabeth Pearson. I am the Plan and ADA Coordinator for Disability and Communication Access Board. I am testifying on behalf of our Executive Director, Kirby Shaw. We stand in support of this measure. We would like to highlight the various federal laws that have come before this, the Fair Housing Act, Civil Rights Act, Individuals with Disabilities Education Act, Rehabilitation Act, Americans with Disabilities Act, Age Discrimination Act. These have all ensured that people with disabilities have been able to have opened up opportunities for people with disabilities to pursue higher education, secure meaningful employment, and navigate the various public spaces with greater independence and confidence. Enshrining these same protections into our state constitution would emphasize Hawaii's commitment to equality. So we stand on our support for this measure, and we look forward to a more accessible future for people with disabilities.
Thank you very much.
Mahalo.
There's many other testifiers. Almost all of it is in support, but that's everybody who signed up to be here in person or on Zoom. Is there anyone else who'd like to testify in SB 1284 here or on Zoom? Okay, seeing none, I will give everybody the statistics on what the testimony was. There were 91 in support, 2 opposed, and 0 comments. Okay, members, on SB 1284, any questions? Okay, I don't have any either. We'll go ahead and move on. SB 1309. This makes appropriations for claims against the state, its officers, or its employees. First up on 1309 is Skylar Cruz, Deputy Attorney General. Good morning.
Good morning, Chair Rhodes, and members of the committee. Deputy Attorney General Skylar Cruz. SB 1309 is the appropriations bill for claims against the state, its agencies, and employees. The bill currently contains 8 claims for a total of $2,338,335.75. Those claims are described in our written testimony attached as Attachment A. Since the bill was introduced, 7 new claims have been resolved for a total of $2,547,898.47. Those claims are described in Attachment B to our written testimony. With the new claims, there are a total of 15 claims for a total amount of $4,886,234.22. We ask that this bill be passed with amendments to add the 7 new claims. Happy to answer any questions.
Okay, thank you. You can stay there. That's only testifier that signed up for SB 1309. Does anyone else wish to testify on SB 1309 here on Zoom? Seeing none. Members, questions? If not, I have a couple. So with regard to the remedial actions, the department has a longstanding policy to advising agency on how to avoid claims such as these. The department has, your testimony just says that the department has complied with HRS 37.775, which requires the AG to develop and implement a procedure for advising client agencies. But it doesn't say, did you actually recommended remedial action in these cases?
Senator, the policy has been in place for quite some time. What we do is we advise clients in writing. It's a confidential memorandum that is sent to each client after a case is resolved, providing a brief discussion of the claim and what remedial action, if any, is recommended.
Okay, so that's my question. So in these cases, did you actually recommend a remedial action to the various agencies that were involved in the claims?
Senators, it's a case-by-case basis. So a letter or a memo is sent to every client. Whether or not remedial action is recommended depends on the facts and circumstances of each case. In some instances, remedial action is recommended. In others, it's not. Okay,
that's okay. So, but your testimony doesn't say whether any remedial action was recommended for anybody. I'm not asking what the remedial action was. It's just my understanding is that you're supposed to, well, I'm going to put it this way. It would be nice to know whether you had actually recommended remedial action and to which people.
We do provide that, Senator, in a written report that's submitted to the legislature, I believe 20 days prior to each session. It's a confidential report that does contain all the information that you're asking about.
Okay. Okay, well, it would still be nice to know in your testimony on this bill that you've actually said, fix stuff. And then I'm sorry. Okay, yeah, so, I mean, my staff raises an important point. So the cases that you report the remedial action on are ones that happened in the past, but it doesn't say anything about these that we're dealing with, at least the second half of the add-ons that we're dealing with today. So you're saying that you don't believe that you're required to report what your remedial action on those was until the report that comes out yearly.
That's correct, Senator. That's my understanding of how the law operates and the department's policy. So the remedial action that is or will be recommended in the cases that are the subject of this bill will be included in the report prior to the start of the next session.
Okay. Well, I guess it would be more useful for us to at least know that remedial action has been requested when we're being asked to write the checks. Let me turn to another topic. So outdated checks. Do you have any explanation for why there's one company that Maui Kupono Builders that had 2 checks. One was over $152,000 and another was over $442,000. It's always boggled my mind that people let any money sit there that's theirs. But do you know what the story is on this particular company, why they didn't bother to cash their checks in time?
I do not, Senator. That explanation was not provided. I unfortunately don't have that information.
Okay. Okay, thank you. Other questions, members? Okay, seeing none, we'll go ahead and move on. Thank you for being here.
Thank you.
Next up is SB 1312 relating to offenses against public health and morals, clarifies that the definition of profits from prostitution includes any money or property accepted or received from the proceeds of prostitution activity, even if it is accepted or received as a reimbursement or repayment of a debt. Next up is, first up is SB 1312 is Albert Cook, Deputy Attorney General. On Zoom, maybe?
They're not present on Zoom, Chair.
Oh, okay. Good morning, Ms.
Apologize.
Nakamatsu.
And good morning, Chair, Vice Chair, members of the committee who may be listening, Deputy Attorney General Tricia Nakamatsu, appearing on behalf of Albert Cook, who is appearing on behalf of the Department of the Attorney General. We are in strong support of this bill, and thank you, Chair, so much for hearing it. This bill would essentially address a case issued by the Hawaii Supreme Court in 2023, State v. Ibarra, in which it was held that profits from prostitution did not include repayment of a loan. In a practical sense, what this would do is create a potential defense or a loophole, if you will, for traffickers who may extend a loan to potential victims, perhaps plane tickets, hotel fares, or just assistance in getting to the United States or to Hawaii in general. And then in return, there's some expectation developed at some point that they're going to repay that loan through prostitution. So we feel that this bill would essentially address that and make sure that that is indeed covered as profits from prostitution. The bill would also clarify certain definitions, consolidate them into the definitions statute, and it would also clarify that promoting prostitution and sex trafficking do not include the prostituted person or the child. Available for questions, if any.
Thank you.
Thank you.
Next up is William Bento, Office of Public Defender. Good morning again.
Morning. Chair and members of the committee, our office does oppose SB 1312 in the way that it's presented. Ibarra, I think, stands for two things. One, the absurd result of the enforcement of the statute, the way it's currently written, being that two individuals came here as equals, one loaned money to the other. They both came here, participated in prostitution, and then one repaid the other for plane tickets and things of that nature. And then one is treated as trafficking the other person when really there was an agreement for both of them to come here together, with the exception of the prostitution part of the agreement. It's almost like two friends decide to come and one gets a job and repays the other person. The other is the term profit. And so the redefinition of the term profit in this bill hopes to take care of that, but it doesn't take care of the absurd result of Ibarra. The language proposed says that a person knowingly receives money or things of value from a third party, and there's an understanding that the person will be repaid through prostitution. But what you're talking about here is the person who's going to engage in the prostitution is the one that's agreeing to receive this money and value. I understand what the Attorney General's office is saying about targeting people who are trafficking others, but I think there'll be a better way to do that than the language in this proposed bill. Thank you.
Thank you. Next up, we have Dara Carlin in support. That's everybody who signed up on SB 1312. Anyone else want to testify on SB 1312 on Zoom or here? Seeing none, members, questions? I have a question for Ms. Nakamatsu, if you don't mind. So I don't know if you're familiar with SB 292, but we're trying to figure out how the safe harbor language, how this bill will work with the safe harbor language of SB 292.
I have read the bill, but we can take a deeper dive look at that if the chair would like.
So essentially it establishes safe harbor protections for survivors of sexual exploitation who seek medical or law enforcement assistance. I don't know, maybe it's not really, not sure how much this bill would change the dynamic there, but could affect it, and that's why I'm asking the question.
Then I'm sorry, I don't even know if our department submitted testimony on SB 292.
If you wouldn't mind, somebody will contact you and we can talk about it if that's okay. 'Cause
Absolutely.
We're just not sure about some parts of it. Can you explain the amendment to the sex trafficking and promoting prostitution statute 712-1202 and 712-1203 on pages 13 and 14 of the bill that prohibits a conviction under certain circumstances?
Oh, that's the portion that essentially means that sex trafficking and promoting prostitution won't result in the conviction of the prostituted person, the victim or the John.
I'm sorry, I missed the middle part.
It doesn't apply to the victim or the John.
Oh, okay. It doesn't apply to the victim. Okay. So then that means, let's see.
If that's their only act in the situation.
Okay, okay. And how confident is the department that the amendments to the definition of profits from prostitution will address the concerns from the Ibarra holding?
That is our recommendation.
You think it'll work? Is that what, that's the testimonies, you think it'll work? Okay. All right, thanks. Members, other questions?
Yes.
Go ahead, Senator.
So, Tricia, I'm looking at the public defender's testimony, and if we pass this bill in the Ibarra situation, and all the lady wanted was a reimbursement of the monies, would she have been convicted? I mean, both of them were prostitutes in the Ibarra case. And she just fronted the money on for one of them to go for the flight, and she just wanted the money back. So one of them who paid for, who asked for the money was not charged with trafficking, but the one who asked for her money back is charged. And if we pass this bill, then she would be responsible for sex trafficking?
It's impossible to predict what the Supreme Court's decision would have been, or whether it would have even gotten to that point. As
That's
you know,
the reason you have this bill, is so that you could prosecute the person who wanted their money back.
yes, as you say. But as you know, every case is very fact specific from the time the prosecutors or the investigators look into the case, to the time the prosecutor screens the case, to the time the court reviews it, and of course, by the time it gets up to appeal. So it's really just, I can't tell you for sure what would have happened, but with the holding in State v. Ibarra, and it was broader than just this very specific type of situation, and we feel that this bill is necessary to close that loophole. You understand? Am I explaining?
No, I understand where you're coming from, but it seems, I mean, the whole idea behind us moving from prostitution to sex trafficking was that we did not penalize the prostitutes. But by doing this, by passing this bill, we're actually penalizing the prostitute who just wanted her money back. Whether it came from a fellow prostitute or somebody else, that to me goes against the whole purpose of why we moved from prostitution to sex trafficking. So thank you. Unless we allow for the Ibarra situation, I am uncomfortable about passing this bill.
So I do have a follow-up question on that. So typically this would not, if there was a loan, it would be from a pimp, right?
Yes.
So in this case, there's some blurring between the prostitute and the pimp. I mean, I don't know the facts of the Ibarra case, so I'm not sure how that would all play out. But would there be a way to carve out who it's being paid to? I mean, I think it's probably why we're all puzzling over this bill, is because it's not easy to figure out how to carve it all out. But if it was if it was someone else, it was another sex worker who was, if you owed the money to, it wouldn't count, or is there blurring there too, or?
Well, I think there's also concerns because, and that's partly, I would imagine why the language say, if the conduct of the person underlying the offense consists exclusively of the person's own acts of being the prostituted person or John, is because there's also the risk that some people could be used as middle management, if you would, so that it could be two prostitutes perhaps, and the money passes through. It's just hard to say. There's so many different ways that these things can be done.
Okay, so.
And so it really would be very fact specific.
Conceivably, a pimp or the pimp's organization would also, it's the person that the money was technically owed to could also be a prostitute, despite the fact that they were principals of the operation.
It is possible.
Okay, other questions, members?
Yeah.
Go ahead.
See, the problem with us not doing a carve out in the like a bar situation is we're back to the a bar situation, because then we rely upon the prosecutorial's discretion on whether or not to charge. And if you have an overzealous prosecutor, which apparently occurred in the Ibarra situation, then even if it's just a reimbursement from one prostitute to another of something minor like they paid for lunch, we're back to, or in this case, it was reimbursement of flight, right? Then we're back to penalizing a sex worker when at a time we really want to go after the traffickers. So that's my main concern. We can't rely upon the discretion of prosecutor because somebody could be super overzealous and just wants to charge.
Okay.
Okay.
Yeah, thank you.
Okay, other questions? No, thank you very much.
Thank you.
We'll move on to the next bill, which is SB 1469. This suspends the statute of limitations on collections during the period an assessment is pending on appeal before the Taxation Board of Review or Tax Appeals Court. First up on 1469 is the Department of Transportation, Taxation, sorry. Good morning.
Good morning, Chair, Rhodes and committee members. Gary Suganuma, Director of Taxation. We submitted written testimony. I'm here to testify in support of this Department of Taxation Administration measure. So what we're trying to do here is the bill would amend various tax types to suspend the statute of limitations on collections during the period an assessment is pending on appeal before the Taxation Board of Review or the Tax Appeal Court. And so the reason we're asking for this is because during the time a case is pending either before the Board of Review or the court, we're prohibited from taking any collection action. And so there is now a 15-year statute of limitations on collections or doing certain types of collections. And so what happens is sometimes these cases will end up before the board and then later in court for many, many years. And really what happens is there's no stay of the statute of limitations right now. And so the 15 years just keeps shrinking. And sometimes by the end of litigation, we only have a few years, maybe sometimes not even. We have some cases right now where the 15 years has already expired and the case is still pending before the court. In that case, it leaves the state in a situation where we could win in the case, get a judgment, but really can't do meaningful enforcement action on the judgment or collection action on the judgment. So all we're asking for here is for the statute of limitations to be held, to be told during while the case is pending before the board or the court. And as the Tax Foundation of Hawaii has pointed out in their testimony, what we're asking for here is similar to what is done on the federal side, where the statute of limitations on collections is suspended for the period that collections is prohibited, or they're prohibited from collections too. So that's what we're asking for. I'm here to answer any questions.
Okay, thanks very much.
Thank you.
Next up is Tom Yamachika for Tax Foundation of Hawaii. Or his
Aloha, Chair. Yes, and members of the committee. This is Jade McMillan on behalf of Tom Yamachika for the Tax Foundation. Yes, we've submitted comments on the measure, just noting that, yes, this is a similar condition that is already in place by the federal IRS. Thank you.
Thank you. That's everybody who signed up on SB 1469. Would anyone else like to testify on SB 1469 on Zoom or here in person? Seeing none, members' questions. I don't have any either. Let's go ahead and move on to SB 1508. This relates to this is the statutory revision bill, amending and repealing various provisions of the Hawaii revised statute or the session laws of Hawaii for the purposes of correcting errors and references, clarifying language, or deleting obsolete or unnecessary provisions. First up is legislative John Morsey, Legislative Reference Bureau on Zoom. Good morning.
Good morning, Chair. The Bureau stands on our written testimony in support, and I'll be available for any questions.
Great, thank you. That's the only person who signed up for SB 1508. Would anyone else like to testify on SB 1508? Members, any questions? Senators, any questions? Neither do I. Thank you for being here, Mr. Morsey. We'll go ahead and move on to the next bill, which is SB 1515, relating to elections, replaces the boards of registration with on-call circuit judges to hear election disputes. First up on 1515 is judiciary. In opposition, Amy Monk for the League of Women Voters. In support, Daniel Freund in support. And that's everybody who signed up on SB 1515. Does anyone else wish to testify on SB 1515? Seeing none, that's the end of the agenda. Let's see. I know there was a conflicting hearing that I'm actually supposed to be in myself. I don't know. I think we just go ahead and vote if that's okay with members who are here.
Yep.
Okay. First up was SB 335, requires objections made by an officer of a political party to candidate nomination papers to be filed with and determined by the Office of Elections. Having heard the objections raised by the Office of Elections and I don't know. I don't think it makes sense to make this change, so I'm going to defer this indefinitely. Oh, we need someone to vote. You mind voting for?
I can, up to you, either one.
Do you want to?
You want to get it before, so it'll be slow.
It's okay. You want to try it? Okay. Joy has taken tons of votes. So I don't think she really needs to adjust any needs. Yeah.
Yeah, there's only 3 of us. It's not hard.
So the first one is, yeah, you can just toss that aside. 335, that one's POW. And then we're up to 280. Okay. Well, 280 is relating to highway safety. This amends the offense of a negligent injury in the first degree to include injuries negligently inflicted by intoxicated drivers. I don't know. I admit I'm on the fence on this one. I think I'll defer it. Is that okay with everyone? Okay, we're going to defer that one too. Close question. Okay, next up is SB 292 relating to sexual exploitation, establishes safe harbor protections for survivors of sexual exploitation who seek medical or law enforcement assistance. This one, and the recommendation is to pass with a couple of amendments. We'll move the definition of seeks medical or law enforcement assistance into the definition section of that part of the chapter, section 712, 1215, and I'm sorry, 1210, and we'll go ahead and put a bad date on it, April 23, 2057. Questions or concerns? If not, Acting Vice Chair Awa.
What do you say in this position, sir? Just call you.
Chair's recommendation is to pass with amendments.
Chair's recommendation is to pass SB 292 with amendments. Chair.
I'll vote yes.
Senator San Buenaventura.
Aye.
And then just call yourself out.
Yep.
Senator Awa. Aye.
And then you just need to note that the other two are excused, which is the far right column.
And excused are Senators Gabbard and Senators Chang.
Okay.
Oh, and then at the bottom of the side of
You can do that later, though. Okay, we'll just keep going for now. SB 301 relating to dogs. This establishes an additional penalty for a dog owner whose dog destroys property while on land that's zoned for agricultural use. I don't know. There's some difficulties with this. There are other dog bills. Would you object if we deferred this and looked at the other dog bills?
My request is keep it alive till conference and then choose which ones you're gonna
Okay,
pass.
that's fine.
Thank you.
We'll just put a bad date on it then, April 23, 2057. So with amendments. Questions or concerns? Seeing none. Senator Watt.
Chair's recommendation is to pass SB 301. Chair, votes.
So with amendments, yes, I'll vote yes.
And I vote yes.
Senator San Bonaventura, yes. I'll vote no. And Senators Gabbard and Chang are excused.
Perfect. Okay, next up is SB 356 relating to driving under the influence requires defendants convicted of causing the death or disability of a parent or legal guardian of a minor child by the operation of a vehicle while under the influence of an intoxicant to make restitution in the form of financial support to each of the child or victim. Recommendation is to pass with text. Questions or concerns? Seeing none, Senator Watt.
SB 356. Chair's recommendation is to pass. You say with amendments?
With amendments.
With amendments. Chair votes.
Aye.
Senator San Bonaventura.
Aye.
I will vote aye. And Senators Gabbard and Chang are excused.
Okay, thank you. Next up is SB 1284, proposing an amendment to Article 1, Section 5 of the Hawaii Constitution relating to due process and equal protection. Proposes a constitutional, where I said that, to prohibit discrimination against a person because of ethnicity, age, disability, religion, national ancestry, sex, sexual orientation, gender identity, pregnancy, and pregnancy outcomes. The recommendation is to make a technical non-substantive amendment. And that's it. Questions or concerns? If not, Senator Watt.
SB 1284. Chair's recommendation is to pass with an amendment. Chair votes.
Aye.
Senator San Buenaventura.
Aye.
I will vote no. And Senators Gabbard and Chang are excused.
Okay, thank you. Next is SB 1309, making appropriations for claims against the state. Recommendation here is to pass with amendments. We'll go ahead and accept the Attorney General's additional claims for legislative relief submitted in attachment B of the department's testimony. So the total claims are roughly $2.5 million. So with amendments, questions or concerns? Seeing none, Senator Watt.
SB 1309 recommendation is to pass with amendments. Chair.
Aye.
Senator San Buenaventura.
Aye.
I'll vote aye, and Senators Gabbard and Chang are excused.
Thank you. Next is SB 1312 relating to offenses against public health and morals. Clarifies that the definition of profits from prostitution includes any money or property accepted or received from the proceeds of prostitution activity, even if it's accepted or received as the reimbursement or repayment of a debt. On this one, not sure we understand the full implication, so I'm going to defer it until Wednesday, February 19 at 10 a.m. So deferred for a set period of time. Next up is SB 1469, suspends the statute of limitations on collections during the period an assessment is pending on appeal before the Taxation Board of Review or Tax Appeal Court. Recommendation here is to pass with technical amendments only. Hang on, just one. Text only? Yeah, okay, that's it. Questions or concerns? Hearing none. Senator Watt.
SB 1469 Chair's recommendation is to pass with amendments. Any no or reservations? Measure passes with 3 ayes and
Okay.
2 excused.
Thank you. Next is SB 1508. This is the statutory revisions cleanup bill for the year. Recommendation is to pass with amendments, just technical amendments. Questions or concerns? Seeing none, Senator Watt. 1508 with amendments.
Recommendation is to pass SB 1508 with amendments. Any no votes or reservations? Seeing none, measure passes with 3 ayes, 2 excused.
Okay, thank you. Next is SB 1515 relating to elections, replaces the boards of registration with on-call circuit judges to hear election disputes. Okay. I'm going to recommend that we pass it with a fairly substantial amendment. So what the amendment will do is if the board of registration does not have its full membership, a complainant can go to the relevant circuit court. The judiciary will designate one or more on-call judges in each circuit to decide these cases. We've had a hard time keeping the full complement of registrars. And so that's hence the reason for this amendment. Questions or concerns? I remember hearing this bill. Did we hear this bill? Did we take testimony?
No one showed up.
Well, nobody showed up. Oh, is that one? Okay, so let's back up. There is one other bill that we haven't actually tried to take testimony on. That would be SB 1515. This replaces the boards of registration with on-call circuit judges to hear election disputes. We did have testimony?
Yeah. Yeah.
Oh, that's right. Okay, all right. Short-term memory loss. Okay. So that's my recommendation for the amendment. Any questions or concerns? If not, Senator Watt.
SB 1515 recommendation is to pass with amendments. Chair.
Aye.
Senator San Buenaventura. I'll vote no. And 2 excuse. Measure passes.
Okay, thank you very much. That concludes our business. Thank you for being here.